Good morning, everyone, and welcome to our webinar this morning on the new UK immigration system. We're delighted to be joined by so many of you this morning, and it's due to the sheer volume of questions we've had on this topic that we've decided we needed to put a webinar on this topic for everyone today. So I'm Claire Sleep, and I'm a partner in the employment team at Ashton's Legal, where we have a number of our employment lawyers and HR consultants. And I'm delighted today to be joined by the partner firm that we work with within the network of law firms we're joined to, IBB Law. So I'm joined today by Richard Duval, and you'll obviously work out who Richard is, and Manisha Patonia, who are both experts in business immigration issues. So they're both from IBB Law and will be talking us through the new UK immigration system. And what the plan is that they will give their presentation for around half an hour or so, maybe slightly longer. And if you've got any questions, post them in the questions function. What we'll do is we will host a Q&A session at the end. So you will see at the top of your screen, there's a chat function. So if you want to chat, feel free to chat. But if you could post your questions on the questions section, there's a button you can press and type in a question, and then we'll try and deal with as many of those as possible that we can at the end of this session. The other thing to point out is we do have a couple of polls running, and I can see a number of you have already voted on one of the polls. I'll make sure I load up the other poll for you, but if you can answer that while we go through and also post your questions, that would be great. So I will hand you over now to Richard and Manisha to start their presentation. Thanks a lot.
Thanks, Claire. Good morning, everyone. Yes, so I'm Richard, and I'm joined by my colleague Manisha. We're from IBB Law. Manisha and I are going to cover off a number of topics today. First of all, I'm going to look at the consequences of the end of free movement, and then look at the position of EU citizens who are already in the UK, just touching on the EU settlement scheme, then focus on the new immigration routes that came in with the introduction of the new points-based system from the 1st of January this year. In particular, I'll be looking at the skilled worker visa route, graduate visa route, and the intra-company transfer route. And then finally, I'm going to touch on frontier workers before handing over to Manisha, who will talk about right to work checks. So as I'm sure we all know, free movement between the UK and the EU came to an end on the 1st of January. And the UK introduced a new points-based immigration system that treats all applicants equally, so regardless of whether they come from the EU or a non-EU country. So going forward, if you are looking to recruit from outside of the UK, the people that you bring in will need some form of permission under the new points-based system to come and live and work here. The new system won't apply to any EU citizens who were already living in the UK by the 31st of December last year. They and their family members are eligible to apply to the EU settlement scheme, and they have until the 30th of June of this year to make an application. If they make an application, it's free to do so. In making that application, that will allow them then to continue living and working here beyond the 30th of June. A successful application, they'll either be granted settled status or pre-settled status. Settled status will normally be given where someone was already living in the UK by the 31st of December. And at the point that they make the application, they've had 5 years continuous residence here. Now, if someone hasn't had that 5 years at the point of application, they will usually be given pre-settled status, which gives them a further 5 years in the UK to allow them sufficient time to apply for settled status if they wish to do so. A few hints and tips on the repercussions of the end of free movement. If you haven't already done so, we would suggest carrying out some form of audit or getting a good understanding as to the extent, if any, that you are exposed if you were to lose some or many of your EU nationals from your workforce. And it's also the time to be looking at your processes to see and check that you have the right processes in place to bring in global talent going forward. So in particular, having a sponsor license or making sure your sponsor license is up to date. And I'll touch on that again shortly. Best practice, and I'm sure you've all been doing it, is to continue to communicate with your EU nationals within your workforce. Update them as to the requirement to apply under the EU settlement scheme for pre-settled or settled status by the 30th of June. And that's both obviously for them and their families. We would also suggest, with the end of free movement, and for the time being, because it's all early days, if you do have EU nationals who are intending to travel back to their home countries, perhaps for holiday or indeed for work, that they carry with them some form of proof of their employment in the UK, so a payslip or perhaps a letter from their employer, just confirming their position. And if they were to be stopped when coming back into the UK, which hopefully is unlikely, but it is possible, they can explain the basis for which they're coming back. If you wish to employ EU citizens in the future, you will need a sponsor license. So if you haven't already got one, then you will need to do so. That application process for a sponsor license is online. There is a fee payable for it, and it depends on the size of the organization. So the fee for a medium or a large sponsor is currently £1,476, and for a small or charitable sponsor, it's £536. To make the application, you will need to be able to produce certain documentation to show that you are a legitimate business, registered for tax and NI in the UK, that you have genuine vacancies that you need to fill, and that you have the policies and procedures in place to adequately monitor any employees that you may choose to sponsor. We would strongly recommend that if you do need a sponsor license, that you make that application sooner rather than later. The processing times were certainly up through to Christmas, were 4 to 6 weeks for an application, but there's every chance that could become longer depending on the number of applications that are being made. Another thing to just check, if you are already a sponsor license holder and you were licensed to sponsor Tier 2 general visas and intercompany transfer visas, just check that they should have automatically been changed to giving you a license to sponsor skilled workers and intercompany transfer workers, and that should be showing on your sponsor license right now. And if it's not, it would be a good idea to contact the Home Office. If you already have a sponsor license, please check that it's up to date, that it hasn't expired, that those people that you have in the required positions, so your authorizing officer, your key contacts, whatever one uses, are actually still with the business, that they haven't left. Manisha and I often have clients where when they check their sponsor license, they find that someone has left 18 months before, and that is actually a breach of the rules. So please check that everyone that is in your system is still with you and able to carry out those roles. Please also check that you have a sufficient number of certificates of sponsorship, because it may be that you're going to have an increased number of applications going forward. So, and that again takes some time to get those certificates in place. And if you were or are a intercompany transfer license holder, please also check that your sponsor license covers all of your legal entities around the world, particularly any legal entities you may have had in the EU, because it's possible that when you applied for the license originally, you didn't include those entities because you didn't need to do so because of free movement being in place. So moving on, I'm now going to talk to you a little around some of the new immigration routes that are now in place with the introduction of the points-based system. The most important one of which I think is the skilled worker visa route. So with effect from 1st of January, people will be able to apply under this skilled worker route. Then they will have to demonstrate that they've got a job offer from a Home Office licensed sponsor, that they speak English to the required level, the job offer that's been made is at the required skill level, which is, for those who wish to know, is RQF3, which is equivalent to A level. Now, actually, that's quite a significant change from the old system where someone was applying under the Tier 2 General. The job offer or the role had to be at broadly a graduate level. So the skill level has come down. And the third requirement is that someone is paid a minimum threshold salary of £25,600, or the going rate for that particular job if it's higher. It is possible to be paid less than the £25,600, but never less than £20,480, because there's this new concept of trading points, which can allow someone to get to the 70 points, which I'll come on to in a moment. And you can get extra points, as it were, if you've got a PhD or the role is on the shortage occupation list. So you need 70 points for an applicant to successfully apply under the skilled worker visa route. You will get 40 points if you have a job offer from a licensed sponsor. You will get a further 10 points if you speak English to the required level. And you will get the final 20 points if the salary is £25,600 or above. Now, as I said earlier, there is this concept of trading points. So you can get extra points if you've got a PhD, an extra 10 points for a PhD, or 20 points if you've got a PhD in science, technology, engineering, or maths. And similarly, if a role is on the shortage occupation list, there's the ability to get a further 20 points there. There is quite a lot of work to be done on the shortage occupation list, I think, going forward, and I suspect over the coming months that list will change, with recommendations being made by the Migration Advisory Committee. But we shall see how that pans out. Another significant change from the old system is previously, where you had Tier 2 General visas, there was the resident labour market test that applied, where you had to advertise the role for 28 days. That is all gone. So there is no requirement now to advertise the role, which hopefully will lead to less paperwork and a much quicker process, because you're going to cut 4 weeks off the timescale, and it should give you increased certainty with the application. All the record-keeping requirements will also disappear with that, so no need to keep the adverts, no need to keep your interview notes, etc., etc. Another big change is that the immigration cap that existed up to the end of last year has now been suspended, which means, so just for those who may not have come across it, there was a cap which said that you can't, within the UK, there can be no more than 20,700 people per year coming into the UK under a Tier 2 General visa, and that was split into monthly allocations. That has now been suspended, so there's no limit whatsoever on the number of skilled workers who can come into the UK. Again, that should speed up the process and provide for a lot more certainty, because you haven't got to worry about whether a particular allocation has already been used up in a particular month. Another change from the old system is that there was a cooling off period. So when someone's visa expired, they couldn't apply for another visa for 12 months following the termination of their original visa. That has now been relaxed quite significantly. So someone who's on a skilled worker visa, when it terminates, will then be able to apply for another visa immediately. So quite a big change there. The immigration skill charge, which existed up to last year, continues to apply. So that is, there is a responsibility on employers to pay £1,000 per skilled worker for the first 12 months of the sponsorship, and then an additional £500 for each subsequent 6-month period. Moving on now to a new route, which is graduates, and I think this is it's great to see a graduate route back in the UK. It hasn't really been available for some years. This is a route which is not currently available, but will be available from the summer of this year. and it's available to international students who complete a degree this summer, and that will allow them to live and work in the UK at any skill level for 2 years following their graduation. That 2-year period is non-extendable. Similarly, if a PhD student who completes their PhD in the summer of this year, they'll be able to stay up to 3 years. Again, it's a non-extendable period. The beauty of this visa route is that it's an unsponsored route, which should make it attractive to business. No sponsorship required, and indeed, there's no fees with this visa route either. From the graduate's perspective, there's quite a lot of flexibility, so they will be able to switch within the UK from the graduate visa into a skilled worker visa without leaving, which will allow them to stay here long term should they wish to do so. And then moving on to intercompany transfer visas. Now, broadly speaking, this hasn't changed significantly from the old system with the Tier 2 intercompany transfer visas. So this is to allow employees who are already working in your business in one of your other legal entities around the world. This allows them to come into the UK or transfer into the UK into a skilled role. As I say, it hasn't changed substantially from the Tier 2 ICT visa route of the past. It still needs to be for a skilled role at a degree level, which of course now is higher than the required skill level for the new skilled worker visa route. The minimum salary requirements that existed up to the end of last year of being paid £41,500 is still the same now. That may change in the future. It's possible that that salary requirement could be higher depending on the particular job that you're trying to fill. There is, as it was before, there's still no requirement to hit a required level of English. And as before, it's not a visa route that will ultimately lead to someone being able to apply for permanent residency or settlement in the UK. However, there is a lot more flexibility now with this route than before, because you can now switch from an intercompany transfer visa into a skilled worker visa route, which will then allow someone, should they wish, to settle in the UK. So again, that's good news. In order to qualify for an intercompany transfer visa, the person will need to be already employed in the business for the 12 months prior to the date of their transfer, unless they're going to earn a salary of £73,900, in which case they don't need that 12 months, and they will be able to stay here for 9 years in any 10-year period. There's also been a change, a good change, to give more flexibility around the cooling off period, which applied before. So you had to wait 12 months before applying for another intercompany transfer visa once your visa had come to an end. That has now been relaxed to some extent to allow for shorter term assignments. So it allows people to come into the UK multiple times for up to 5 years in any 6-year period. So hopefully that will allow companies to bring people in for short-term assignments without each time there having to be a cooling off period. And as I said earlier, please check your sponsor license that it is covering all your legal entities. It's a simple thing to check, but it's important to do so. And then finally, moving on to frontier workers. A frontier worker is someone who is from the EU or the EEA or a Swiss national who started work in the UK by 11 p.m. on the 31st of December, i.e. the end of the Brexit transition period, who was primarily resident outside of the UK, and they may have been or may be employed on a self-employed or indeed an employed basis. Now, on the 10th of December last year, the government launched the Frontier Worker Permit to allow frontier workers from the EU, EEA, Switzerland to retain that status and to be able to continue to come into the UK to work. To be eligible for the permit, the applicant will need to live outside the UK, have worked in the UK at some point by the 31st of December, and have kept working in the UK at least once in every 12-month period. Living outside the UK means that they're primarily outside of the UK, which generally means that they have spent less than 180 days in total in the UK over the course of any 12-month period. To show that you've worked in the UK, you need to just show that you've come to the UK at least once in every 12-month period, and that happened before the 31st of December 2020. The Frontier Worker Permit is a free application. It's very similar to the application under the EU settlement scheme. It can be made online, and it can be made from inside or outside of the UK. The scheme will produce an ID check app, which will verify their identity, and it will give them a digital status. The permit is normally valid for 5 years. They may get a physical permit as opposed to a digital status if they don't use a smartphone app when making the application. Those permits can be renewed, providing, of course, the person continues to hold the eligibility requirements. Frontier Worker Permits don't give someone the right to come and go as they please into the UK, but they do give a right of admission. They don't give the person the ability to stay in the UK long term, and it might be that actually they are better off applying under the EU settlement scheme, assuming that they are eligible to do so, which will give them more permanence here and more flexibility going forward. Just from a how does a Frontier Worker Permit, or how do frontier workers come into the UK? Between now and July, all they'll need to do is just produce their EU passport or their national ID card. But from the 1st of July, they not only have to produce their ID when they come in, but they also need to produce the Frontier Worker Permit in order to be given access to the UK. So at this point, I'm going to hand over to Manisha, who is going to talk to you about right to work checks. Many thanks.
Thanks, Richard. Hello, everyone. So Richard has run us through some of the visa routes for employees and workers, but what about freelancers and self-employed individuals? There has been a lot of commentary about the new system not catering for self-employed workers and freelancers. There is not a dedicated self-employment route or visa. Self-employed individuals will need to look to other visa routes, such as the startup route or the innovator route, or the routes that Richard outlined earlier. The problem is that the startup route and the innovator route have very stringent eligibility tests. Both of these routes cater for applicants that want to set up their own business in the UK. However, in order to be eligible, the businesses must be innovative and must be different from anything else in the UK market. This means that realistically, most self-employed individuals will require sponsorship in order to remain and work in the UK. So moving on, I also wanted to spend a few moments talking through the right to work checks that you as a business should be doing when taking on new workers and employees. And also to run you through what has changed as of the 1st of January 2021. So as you probably already know, all employers in the UK have a responsibility to prevent illegal working. It is incumbent on employers to identify whether they are legally able to employ an individual before doing so. Employing an illegal worker can have severe consequences. The Home Office takes a very hard line against any employers that intentionally or negligently employ individuals that do not have the right to work. Employers can be imprisoned for up to 5 years and can face an unlimited fine if they employ somebody that was known or could reasonably have been known not to have the right to work in the UK. Provided, however, that you carry out the right to work checks properly and diligently, and you deem that an individual does have the right to work in the UK, you can rely on the statutory excuse to avoid penalties and/or criminal action if you are later found to have employed an illegal worker. The statutory excuse is a defence that can be relied upon in the event that an individual manages to rely on fraudulent documents or something similar. Moving on to the practicalities of the right to work checks. There are two ways to check an individual's right to work. This can be done either manually or online. It is prudent to check both ways, but if you have completed a manual right to work check, you do not necessarily have to complete an online right to work check as well. When doing a manual check, you should refer to the government website for the right to work checklist. You must check the documents from either List A or List B on that checklist. List A contains a range of documents that can be accepted for individuals that have a permanent right to work in the UK, whilst List B contains a list of documents that can be accepted for an individual that has a temporary right to work in the UK. You must also ensure to retain a copy of the completed checklist on the personnel file. It is important that when you do a physical check on the documents, you do so on the original documents. Copies are not sufficient. When completing the check, make sure to check that the name and the photographs on all documents are consistent and that they match up, and ensure that the documents have not expired and that insofar as you can tell, the documents are genuine. When checking passports, you should also do a quick check on all pages of the passport, not just the photograph page. Take copies of all the documents that you have checked and ensure that the copies are signed and dated by the checking officer. It is important that the right to work check takes place before the individual actually starts work with you. As such, if the individual is due to start work with you on the same day that you're doing the right to work check, make sure that you do sort of a record of when you completed the right to work check, and make sure you put a time stamp on that right to work check as well. The paper trail is very important, and it ensures that the statutory excuse can be relied upon if it's needed later. The Home Office requires employers to keep copies of documents on file for not only the duration of employment, but also for 2 years following the termination of employment. So moving on then to online right to work checks. So in 2018, the government launched an online right to work checking service. This checking service is available on the government website, and it allows employers to check real-time information about potential employees and applicants. The online checking service is an attempt by the government to streamline the immigration system. However, it is reliant on you being authorized as the employer to have access to an individual's information. The way that it works is that the applicant accesses the online checking service. They receive a share code, which they then share with you as the employer or the potential employer. And then you go on as the employer and check that individual's documentation and their right to work on the government website. The service is voluntary and it's not strictly necessary if diligent manual checks have been taken. If you are completing an online right to work check, make sure that you screenshot the results with an electronic date stamp and signature. This should also be retained on the personnel file for at least 2 years past that individual's employment termination date. Moving on to subcontractor and third-party checks. So all employers are obligated to check an individual's right to work if they seek to employ somebody that is under a contract of employment, a service, or apprenticeship agreement. There are a couple of exceptions. For example, where an individual is engaged by an agency or a third party, and where there is not a direct employment relationship between you and that individual, the obligation to check that individual's right to work might not rest with you, but might rest with the third party contractor or agency. Further, when you are engaging somebody that is genuinely self-employed, again, there might not be an obligation for you to check that individual's right to work, provided again that you do not have a direct employment relationship with that individual. And you might notice that I've said you might not have the obligation to check. The reason that I say that is because these exceptions are very fact sensitive. Employment status is very much a grey area at the best of times, and it is extremely difficult to know and to tell if an individual is a worker or if they are genuinely self-employed. As such, we would strongly advise that if you were to seek to rely on one of these exceptions that I've outlined above, that you do seek bespoke advice before you do so. Moving on then to what has changed as of the 1st of January 2021. in terms of right to work checks. So actually, practicality wise, not very much. You are still obliged to follow all of the steps that we've mentioned and to complete the checklist as we have mentioned. You should still be checking all passports and ID cards. However, the government has announced that at the end of the transition period, that being the 1st of January 2021, there will be a 6-month grace period in force, and that will last up until the 30th of June 2021. During that period, employers are not allowed to discriminate against EU, EEA, or Swiss nationals. EU citizens that entered the UK by the 31st of December 2020 are able to apply for pre-settled or settled status via the EU settlement scheme. Applications must be made by the 30th of June 2021. Individuals that enter the UK after the 1st of January 2021 do not have the automatic right to work in the UK and therefore must have a visa in order to do so. This means that as of the 1st of January, we now have 2 types of EU workers: those that can rely on their status under the EU settlement scheme and those that need a visa to work. This is problematic in light of the grace period between the 1st of January and the 30th of June. The government guidance explicitly states that employers are not able to ask individuals whether or not they have settled or pre-settled status until after the 30th of June 2021, and employers are not able to discriminate against such workers. This poses a massive problem for employers, and we're eagerly awaiting more precise guidance from the government as to how to navigate the right to work checks during the grace period. We will be updating our website and our newsletters as soon as we know anything more about it. However, in the meantime, our advice to you as employers is that you must satisfy yourselves that individuals do have the right to work in the UK. You therefore must complete the right to work checks as we have outlined. You should also be asking when an individual arrived into the UK. This will indicate whether or not that individual does have pre-settled status or whether or not they're eligible to apply under the EU settlement scheme. You are also able to encourage individuals to apply via the EU settlement scheme. What we do know is that a lot of individuals are quite reluctant to apply via the EU settlement scheme. So therefore, if you know of any individuals in your current workforce, you should be encouraging them to sort of apply, sending the emails and updating them. They do have up until the 30th of June to apply. If you are aware that an individual arrived into the UK after the 1st of January 2021, you can reasonably assume that that individual does require sponsorship and therefore does not have the automatic right to work in the UK. So that's it from me. I think we are now moving on to questions.
Yes, great. Thank you so much, both of you. That's taken us through the system in a really clear way. So thank you very much for that. And I'm pleased to say that while you've been talking, you have had quite a lot of questions come in, and there may be more to come. So I've got the easy job. I'll just ask you the questions. And if there's something that we can't get back to you on today, then we can follow up on that. So if I go through these, the first one I've got is from Mikkel Rocker, and that is can the application, and I think this was when we were on the skilled worker section, can the application be turned down if a British national can take the role offered to the non-British potential worker? In other words, do you have to establish that the skill needed to recruit the non-British worker cannot be found in the UK?
Sorry, guys, I was on mute. No, and that's the good news, is in a sense, because with the resident labour market test going, provided you hit those basic criteria of being sponsored, hitting the salary threshold, and it's at the required skill level, which is A level or above, that is sufficient. There is no, the resident labour market test has taken that point away, really.
Brilliant, thank you. Hope that answers your question, Mikkel. And the next one I've got is from Emma Walters, who again So she was asking, her first question was about the graduate route slide you had, Richard, and that was, is the graduate route only available for new 2021 graduates, or is it for any graduates?
It's available to anyone who graduates in the summer of 2021. So I guess you may have already started your course. That's my understanding anyway. Yeah, because the trigger point is the graduation.
Brilliant, thank you.
I should just say, just going back to the previous question, there is still a requirement for there to be a genuine vacancy. So there has to be a reason why you're bringing someone into the UK, and that the genuine vacancy point will be something that the Home Office will continue to check.
Okay, great, that's helpful, thank you. Emma Walters also asked about, and she was asking when you're on the skilled worker section, she said, does the PhD only count on points if it is required for the post?
No, I don't think it does actually. I think if you've got a PhD, that is sufficient, whether or not it's of use to the particular post. That's my current understanding. It's possible that further guidance might come out about that, but I think it's just sufficient to have a PhD.
Brilliant, thank you very much. I've then got a question from Leanne Day, who has said, please can you explain more about the sponsor license covering all legal entities? So I don't know if that was one for you, Manisha.
Well, it may be both of us, but let me start. So what I was suggesting was, so this only applies if you are anticipating or have used in the past the intra-company transfer route. So this is where you are bringing someone in from one of your other subsidiary companies or one of your other legal entities in another part of the world, and you're transferring that person from, for argument's sake, now from, say, your French business to your UK business. It's just making sure that all of your entities, in that example, the French business, is actually included under your sponsor license as a legal entity that you may wish to transfer from. But it won't apply if you're not doing the intercompany transfer route or not proposing to use it, or indeed if you haven't got any other entities in other parts of the world.
Makes sense. Great, thank you for that. Then got a question from Paul Furness. Hi, Paul. And he has said that his company employs a lot of individual subcontractors, normally legal status sole trader. So they employ a lot of subcontractors each week, and it is fairly high volume. And they're typically carpenters, and they've traditionally applied the basic right to work checks, but are asking, do they need to do anything different from now on? So that was the first question, and then he's got a couple of others, but I'll stick with that first one.
Manisha, do you want to deal with that one?
Yeah, sure. So this goes back to the point about that there's no dedicated route for self-employed individuals. So our understanding is that those individuals will need sponsorship in order to continue working in the UK past the 1st of January. So it seems to me as though you would need to go through the sponsorship route as a skilled worker, as opposed to those individuals continuing to sort of be employed by their personal service company or similar.
That's great, thank you. And then he's gone on to say, how do we evidence an individual has been in the UK prior to 1st of January this year?
Yeah, this is the big problem. You can't. So we can't be asking individuals as to whether or not they have pre-settled or settled status, but you can ask the question as to when they arrived into the UK, and you can sort of ask very clever questions. For example, you can look at somebody's job history to assess, if they've been working in the UK before that date. But yeah, it is a big problem, and the Home Office are quite aware that this is posing a problem for employers and the right to work checks.
Thanks, Manisha. And the last bit of the question is, once they have EU settlement scheme approved, how is that evidenced as part of their checks?
Manisha, do you want to deal with that, or do you want me to deal with it?
You can go ahead if you want to.
It's basically a digital status, and if they give you if they're prepared to give you a code that allows you to access the system to check what status that they have, but it's entirely at their discretion whether they wish to give you that information. But it is a digital status, and you can also potentially check rights to work with the Home Office as well through their employment checking service.
Great. Okay, thank you both for that. I think that's the end of his questions now. So I've got another one from Mikkel. Hi, Mikkel. And he says, can one have pre-settled status when working for company X and then leave that company to work on his own business? Will that person lose his pre-settlement status, or does the system protect entrepreneurs and small business owners?
No, they won't lose it. So the basic requirement for the EU settlement scheme, be it settled status or pre-settled status, is that the person was already here, living here, by the 31st of December 2020. It's not attached to where someone's employment is, or indeed whether they're employed. It is simply about were they here or not at the end of last year. So they can move around as they wish.
Lovely, thank you very much. We have got a few more, but you're giving these fairly short shrift. That's brilliant, thank you.
Sorry, Claire.
That's perfect. I'll carry on with a few more questions, if that's okay. So I've got one from Karen Close. Hi, Karen. What documentation do we need to get existing EU staff to show to evidence settled status?
Manisha, do you want to deal with that one?
Yeah, sure. So again, we simply can't be asking for a confirmation of settled or pre-settled status, but we can be asking for sort of job history and things like that. If an individual does want to volunteer up that information and give evidence that they do have pre-settled or settled status, then obviously that's brilliant, and we can take that on board. But we can't physically force them to give it to us.
Okay, that's great. And she's got a second part to her question to say, what would we need to do if an existing member of staff from the EU failed to apply for settled status by the June cut-off date?
Yeah. So if that happens, then that individual has lost the right to apply via the EU settlement scheme, and therefore they will then need sponsorship. They do not have the right to work in the UK as of the 1st of July, and they will need sponsorship in order to continue working.
Brilliant. Thank you very much. I've now got one from Ellie Clements, who has said, just to clarify, can we ask our current employees about their settled or pre-settled status, or is that possible discrimination?
It is possible discrimination. So no, we shouldn't be asking that explicit question, but we can cleverly ask when they enter the UK and things like that.
And I think it's the situation, if you ask everyone the same question, then you can't be discriminating. Yeah. Okay, great. Thank you. I've got Christina asking a question. I think we might have had this one, but I'll ask you again. How can we determine when someone has entered the UK, i.e. proof?
That's a good question, actually.
Yeah.
I mean, if you're coming from the EU, you're not going to have a stamp in your passport or anything like that. I think the answer to that question is you've got to take it on face value. If you ask the question and they say, I came in on whatever date, you're entitled to take that on trust, as it were. As Manisha said, you can also back that up by looking at their working history in the UK, perhaps. But yeah, there's no...
Plane tickets.
Plane tickets might be an option. Yeah, it sounds a little bit intrusive to do it that way, but I think there comes a point where if you've asked that question and you had an answer, that's probably, I think you're entitled to rely on that answer to a large extent.
Great.
And you should be keeping sort of a paper trail. So if you've asked the question and they've told you a date, then you should be noting that down, just in case it turns out that actually that they weren't telling the truth.
I mean, it's only going to become will become a live issue clearly on the 1st of July, if at all, and that's when we find out whether someone has been telling the truth or not.
Yeah, she has added on to that. Is there a date on the passport when they come through the airport, for example? And I think the answer to that you've just given is
well. I don't think from the
EU.
From the EU, no, and I'm not aware of that is going to be the case from the 1st of January either. I don't think there's any intention to stamp passports. That may change, but I'm not aware that there's been a requirement for the border guards, border officers to stamp passports for EU people.
Great, thank you very much. Got a question.
Not least because actually you can come in with a national ID card from the EU country, so it doesn't necessarily need to be a passport that you're using.
Great, thank you. We've got a question from the Anglian group, and have said self-employment is suggested they would need to be sponsored. Does that not pose a very grey area with HMRC indicating employed status, or will it be clear sponsored can be for both employed and self-employed?
Yeah, I mean, the answer is yes, it does pose quite a big grey area, because whilst there is an exception for self-employed people, it's very difficult to tell if somebody is genuinely self-employed or if they're workers. And in most cases, when we come to sort of the employment status scenario question, it turns out that there is an element of worker status, and if that is a risk, and if that is something that could happen, then sponsorship should be explored.
Right.
I think it's an area that I expect to see quite a lot of developments in over the next few months, because there's a lot of industries who are pushing the government quite hard to try and get more clarity around the position of self-employed individuals. I mean, the construction industry is an obvious example, but there are lots of other industries as well.
Thanks for that. I've got one from Tiffany Palmer, who has said that they have some EU nationals who've been working for them last year and have gone home now due to the pandemic. If they come back, what do I need to check? Do I assume that as we have checked their info before, they're still okay to stay with us?
I think you can make that assumption. Yeah, so well, certainly through to the 30th of June. Yeah, I think you can. Manisha, have you got anything to add to that?
I think you should be sending across emails, sort of generic emails, encouraging people to apply for the EU settlement scheme before the 30th of June. And that's all you can really do. But as Richard says, you can take it sort of as read that they've been in the UK before the relevant date, and therefore you would assume that they have applied, or that they are still able to apply.
Great, thank you. I've got one from Linda Drain to say, if we become aware that an employee appointed between 1st of January and 30th of June this year, so during the grace period, was not resident as at 31st of December last year, and they did a right to work check in good faith, and then it's ended the question. She just said, do we? So I suppose she's saying, is it a problem if that happens?
If you don't believe what someone is saying to you and you have reason not to believe it, then you may want to think twice about employing them, quite frankly, because your paper trail is not going to support, if you're ever questioned by the Home Office or it becomes a problem, your paper trail is not going to support your position. So if you're nervous, you probably have good reason to be nervous. So you need to tread carefully, I think, with that sort of situation.
Right.
And I mean, this, as Manisha said, this grace period is difficult because you're limited. You're a bit straitjacketed as to what you can ask about. There has to be an element of taking answers to questions on face value. And as Manisha said, provided you've documented what you've asked and you've taken some reasonable steps, that should give you the protection that you need. But it would be, I can understand it will be difficult if you think someone is not telling you the whole truth about their position.
Yeah, sure. Hopefully this is a quick one. And somebody just asked about the graduate route and said, is that only for EU graduates or for global graduates?
No, sorry. Yeah, going back to that's for everybody, non-EU or EU, and that's the point really. Is that the new points-based system doesn't discriminate in any shape or form. It is everyone now from around the world is equal, and there's no special status for EU citizens beyond the EU settlement scheme. So it applies to everybody.
Brilliant. I've got a couple now who have got other people voting. They also want this question answered. So the first one is from Leanne Day saying, if we can't be satisfied that a potential candidate entered the UK before 31st December and they will not provide the share code, is there a potential cause for discrimination if we choose not to hire?
Yes, I suppose is the answer. But then there's degrees of risk, isn't there? It's not the questions that have been asked in that scenario are reasonable questions, and if you don't feel like you're getting a reasonable response, there is a risk, albeit I think a very small one, because you are behaving reasonably ultimately, and they are fair questions. Manisha, do you think? Have you got anything to add to that?
I agree. I think as an employer, you have to weigh up sort of the risk of discrimination and the risk of employing somebody that doesn't have the right to work in the UK. So it is difficult, and yes, there is that risk. But I think if you ask sort of the question at the right period, if you're asking it blanket a question across sort of the whole workforce, you've got to take a decision at some point. But if there is potentially another reason that you can justify something like that, it is sort of fact sensitive, but you've always got to weigh up those two conflicting things between now and the 30th of June.
Thank you very much, both. Sounds very sensible.
And so moving on that slightly, I think Manisha mentioned earlier, but what you can't do absolutely is make a decision whether you're going to recruit someone or not based on whether or not they have settled or pre-settled status. That can't happen. I think Manisha, you dealt with that earlier, didn't you?
Yeah. Clear. Okay, we've got one that's got a couple of other people want this answered, but it's quite a specific question. Paul Church is saying about HGV driving is a skill, but not on the government skilled list. How do we employ them after July 21st if we cannot be sure they will earn the minimum amount?
Right. We've got the route that is likely to apply is the skilled worker visa route. As I set out, the person will need to get the required 70 points. Now, I completely understand that that may be difficult for I don't know what that particular role pays, for instance, but that may be an issue. There isn't an answer to that question at the moment. If the applicant can't get to the 70 points, then they will not be successful with that skilled worker visa route. There are, as I said, I think I touched on, the list of what will be on the shortage occupation list will change. Sorry, HGV drivers. Sorry, I'm just going back to the question itself. If you're talking about people moving across Europe in a logistical sense, there are some exceptions around that for deliveries, etc. They won't need a visa to come and go. I think they will probably fit into the frontier worker point. But I can look at that in a bit more detail if you wish, and offline. Manisha, have you sort of looked at the HGV drivers specifically?
I haven't, unfortunately, no. So I don't have much to add to that.
Okay.
Why don't let me see what I can find on that.
And what I'd suggest, Paul, is you've got Richard and Manisha's details. Is if you get in contact with them directly on that point.
Yeah, I'm delighted to have a look at it. Yeah.
Great. We've got another question from the Anglian group who are saying the new immigration rules aren't just for the EU. This immigration is not just for the EU, but now an open playing field or equally open for global applications. how will that affect grandparent or parent entry and 2-year working holiday visas for New Zealand, Australia, South Africa and Canada? That might be fairly specific.
I believe that the yeah, I think the position is that the Australia-New Zealand position remains as it was, but I'd probably like to look at the up-to-date guidance around that. The government have been trying to streamline everything as best they can. It's probably another one to come back on, actually, if I may.
Yeah, that's absolutely fine. And that one's Lisa Johnstone.
Okay.
Thanks, Lisa.
So sorry, that was Australia and New Zealand, and what was the other elements to it? There was another part to that question, I think.
How will that affect grandparent and parent entry?
Grandparents, thank you. Yeah.
Okay. We've got another 5 questions here, and they're keeping coming in. So we are at 11 o'clock now. So shall I say we've got one that's got 1 vote? Shall we answer the one with 1 vote, or are you happy to deal with all 5?
We're pleased to pleased to try and deal with them now if people wish.
Okay.
Whatever's best.
Okay, great. Thank you, both of you. Well, we'll deal with the one that's got 1 vote from Bev Gaffney, who has said the government website still says how you check EU, EEA or Swiss citizens' right to work in the UK has not changed. Even though the UK has left the EU, they can still use their passport or national identity card until 30th June 2021. Do you have any comments on that?
That's absolutely right. That is right. So nothing's changed in terms of the documents that you need to check. But I mean, I suppose it goes back to the questions that we've been answering around sort of the grace period. You've just got to bear in mind that there is this sort of 2-tiered EU national situation where some of them, that they might not have that settled status or pre-settled status. So you just got to bear that in mind. But in terms of the actual documents that you are checking, yes, nothing's changed in terms of those.
But the point being is that as of the 1st of July, those documents will not be sufficient necessarily. So it comes back to asking some sensible questions now on, the documents from a document's point of view, that's all you need. But it's just asking those additional questions to give yourself a bit more certainty that actually they've got the right to be here long term.
Great. Okay. I've got another one from Emma Walters, who says the new additional visa costs are potentially going to lead to employers discriminating against EU applicants once settled status closes. Can you advise employers how to navigate to avoid this whilst managing reduced budgets?
That's a very good question. Yeah, I mean, I agree. Actually, the idea of introduction of fees may make someone you may be less inclined to recruit them. But I suppose an EU citizen now is no different to a non-EU citizen. It is to the advantage, I guess, to the local workforce. But I suspect the government would say that's what they're looking to achieve. I'm not sure I have all the answers to that question at the moment. I think it's probably something that can develop over the next few months. But I can absolutely see the argument and the risk attached to it. But I think what underlies this, there is clearly government policy behind this, which is to try and encourage people to recruit locally.
I've got one from Dinos now, who is asking.
Sorry, that's not a great answer, but that's probably the best I can do at the moment.
Status, but due to the pandemic, I will spend over 6 months abroad. What actions do I need to take regarding my status and taxes?
Taxes, I'll speak for Manisha on this one as well. We're not tax experts. Recommendation there would be please have a chat with a tax advisor just to understand the tax implications of it. I don't think being outside of the UK for that period of time, and there is some flexibility around the pandemic and a recognition that people may have been stuck in certain locations or outside of the UK longer than they expected. I don't think that's a problem. In other words, I don't think it adversely affects the status that you've got.
Okay.
Manisha, I don't know if you've got any further thoughts on that.
No, I agree. I mean, you've got the status, so that will remain in play, is my understanding.
Settled status and pre-settled status, but after the 1st of July, we'll need evidence. Does this also apply to existing employees?
I think it does, yeah. I anticipate that you will be essentially carrying out an audit at that point, really, of your entire workforce. That's probably the right time to be carrying out your right to work checks and just checking that everything's up to date. Yeah, Manisha, do you agree with that?
I agree. Yeah, I mean that obligation, it applies not only to new employees but also to existing employees. So yeah, absolutely, you should be checking sort of on the 1st of July or as soon as possible, really.
Oh, that really, all roads lead to somewhere soon after the end of June, whereby businesses, I think, will be expected to have a proper audit of their business.
Okay, great. And we've then got one from Ali Bass to say, if an EU member of staff doesn't obtain settled status and therefore would need sponsoring to remain employed, are we obliged to obtain a sponsor license and sponsor them if they meet the points, or can we end their employment?
No, there's no obligation to have a sponsor license and no obligation to sponsor. And yes, you could end their employment, albeit subject, of course, to employment law and behaving reasonably, etc. But yes, you could end the employment on that basis.
I need to close.
Let's see.
Okay, and then we've got one from Tiffany Palmer, and I think this might be the last one, to say, we're checking our HR files for proof of for what that should be in there for everyone who started. We found an employee who has worked for us for over 10 years, and we have no proof that they can work in the UK. He is still failing to supply the information, as he says he has changed his surname when was young and lost the paperwork. We do believe he is British, but what would be the penalty if we were audited and found not to have the appropriate information for him?
Manisha, you're right.
Shall I go? And then you can add on. So the penalty is anything up to 5 years imprisonment and an unlimited fine. So the penalties are quite stringent, really. And I think now that you have this information, you should be taking reasonable steps to ensure that you are satisfied that this individual does have the right to work. So to me, it's not sufficient that he's refusing to give up that information. And to me, I mean, it sounds to me as though it could lead to dismissal. Rich, I don't know if you agree with that position.
Yeah, Manisha's right, but I don't want to put I don't want to scare the living daylights out of you. I would be surprised, famous last words, that whether prison was ever a sanction instigated for that sort of situation. It is possible that a fine might be forthcoming of some degree. The best thing to do would be utilize the online right to work checking service. I think that gives you the statutory defence.
It does, but the online checking system is sort of reliant on that individual authorizing you to check his data. So if he hasn't done that, then obviously you won't have the right to do it. But yeah, I mean, those are the things that you could do.
But I mean, ultimately, again, you're asking reasonable questions. If they are not prepared to give you that information, you are moving into the realms really of some sort of disciplinary type situation, to take them through a process to find out why and what the position is and why they're not prepared to share it. Yeah, I mean, that's it would be unfortunate. I don't think the explanation that's been given in that example is sufficient, to put it that way, for you to just continue to, at face value, continue to leave it there and just let them be employed. There needs to be greater clarity,
Okay,
I think,
thank you very much. I think as a
what you have
final
currently.
question, David Tassel is saying that they have 2 permanent subcontractors living in the EU. They would have periodically visited the EU for work over the last 6 months, except the office was closed due to COVID. Can they apply for frontier worker status?
Potentially, yes. There is, yeah, potentially they might be able to. There is some leeway under the permit because of the pandemic, etc. So yes, and bear in mind that application process is free, so it might be worthwhile giving it a go. Frankly, the worst that can happen is that it's not granted. But yeah, it might well be a route that works.
And I think as an absolute final, we've got Cassia, who has asked what happens if an existing employee does not obtain settled status by 30th June. Presume you can ask employees whether they have the status after the grace period. Do we have an obligation to obtain a visa for them?
Yes, you can ask the question after the 30th of June. No, you do not necessarily have that obligation to apply for a visa for them, but it's quite fact sensitive, really. I think at that time you'll need to assess sort of if you want to continue employing that individual, but there are potential justifications that you can go through if you wanted to terminate.
Yeah, and you're right, Manisha. There is no requirement to sponsor someone. It's a question really of how much do you wish to retain the services of that particular individual going forward, and unfortunately the only way, if you want to retain them, they're a valued employee, then you will need to sponsor them. At the moment there's no third way as such.
I can see in the chat as well that people are grateful for those responses, and so I'm going to move on and have a look at the poll session, and I can see that it looks about 50-50. So we've got 43% have said yes, they've got a sponsor license, and 58% have said no, they haven't. So I don't know if that is similar to what you're seeing across the UK workforces, Richard and Manisha.
Yes, it probably is. It probably is, actually. It's the fact of the matter is there are lots and lots of companies that don't have the benefit of a sponsor license, and that means that they're in a position where they just can't access the global talent pool. And if you were reliant on the EU beforehand, unfortunately that's no longer available in the same way. So it's I think it is probably a fair representation. If anything, I'd say we're probably seeing a higher percentage of companies without a sponsor license than that 50 odd percent, probably more heading towards the 60 odd percent. You can actually go online and have a look at the sponsor license register, which is a public document, to see all the companies in the UK that have got a sponsor license. And believe me, there are lots and lots of companies that aren't on there,
who are likely to have a sponsor license. Thanks.
I think that's probably right. Yeah, and it's another one of these classic. I suspect we've all been a bit sidetracked by the pandemic for obvious reasons, but Brexit has snuck up on us, and it's what we are seeing is lots of companies are thinking, oh my word, we may have a problem here because we haven't got a sponsor license, and but it's not too late.
No. Well, thank you very much for that. And the other poll we had, so moving on to more employment law topics, we did ask you the question from a HR perspective, whether employee wellbeing was in your top 3 priorities for 2021, and we've had a resounding 96% saying yes, it is, and that we're just seeing if that's true from the session we did before Christmas in around November, when the poll was saying that this was your top priority. So it seems that that is still a very high priority for the majority of employers. So it just remains today for me to say thank you so much to Richard and Manisha for joining us today and answering all of those questions so concisely. I can see there's some more bits in the chat, so if we haven't answered anything today, then please do get in touch and we will do our best to come back to you. You've got Richard and Manisha's details, you've got our details, so any immigration queries, then do send them over to us and we will make sure that we come back to you on those. Just to say, from a HR perspective, we do have a number of training courses running, and I've put up the leaflet that we've got, and if anybody would like a copy of this with details of our online training, then just let me know and I can forward that to you by email. And also to let you know that we have a session running on the 9th of March, which will be a wellbeing session. It'll be another webinar on employee wellbeing, where we will be joined by the CEO of Suffolk Mind. So do look out for that session coming up, because I know it's a topical area for you. So thank you very much from me for joining, and we will see you in March for our next webinar, and we very much look forward to your questions coming through. So thank you, everyone.
Thanks very much. Take care all.
Thank you.
Thank you.
Thank you.